So the Supreme Court just heard the arguments from the NCAA in their case in NCAA versus Alston. I want to talk about the timeline about where this comes from, as well as what the Supreme Court justices was feeling about it. All that coming up in about 20 seconds. What's good, everybody? It's your boy Jay here with Unfair Sports, where we take a pensive approach to the sports conversation. And today I want to talk to all of you about this case, the NCAA versus Alston, which is the big case around player compensation. So the Supreme Court, let me step back. So the Supreme Court heard oral arguments on Wednesday from the lawyers for the NCAA about their argument against the case on NCAA versus Alston. Now, let me give you a timeline of kind of how that went down. So in 2014, Sean Alston and a collective group of student athletes, men and women, filed several antitrust complaints against the NCAA in district court, Northern District in California. The complaints say that the compensation system violates antitrust laws. Now, the NCAA is fighting back, saying that the case, which was O'Bannon versus the NCAA, settled this already at the time, and the rules are in place to preserve student athletes' amateur status. We'll talk more about amateur status in a bit. The players, of course, claim that there are less restrictive alternatives to preserve, which is called LRAs, to preserve this, as the NCAA allowed to use players' name, image, and likeness, but the student athletes are prohibited from being compensated for the same thing. So for more details on this, like more in-depth, get more granular, you can always Google the case NCAA versus Alston, ALSTON, on Ballotpedia, which is where I got the information from on it. But that was 2014 and how this started up. Now we're here in 2019, the Northern District of California held that the NCAA's limits on education-related benefits unreasonably restrained trade and enjoined or prohibited those limits. So basically, they said, you're full of crap. And so now they didn't say that the NCAA violated the Sherman Act, which is, antitrust, but they did implement the student athletes' proposed IRA, which is the LRA, which is the less restrictive alternatives, via a preliminary injunction, basically agreeing with the kids, saying that, yeah, this isn't cool. Yeah, these rules are ridiculous, and there's other alternatives to players, being compensated. I think it's fair. And so from there, the NCAA appealed it to the 9th District, and the 9th District actually sided with the Northern District of California. Because of that, now we are where we are now. We are now at the Supreme Court. And it's very interesting how this is going down, because in its essence, the NCAA is arguing that the reason why we're not paying these kids is because you, the fans, want us not to. And that's what makes the product so great. Sounds really bad when you say it that way, right? Let me show you what they said. So the NCAA is saying the lower courts have improperly redefined amateurism. Now, let me give you a quote from the attorney, Seth Waxman, for the NCAA. This is what he said in his oral argument. This is the rare product that is defined by the restriction on compensation, Waxman said. For more than 100 years, the district character of college sports is that it is played by students who are amateurs, meaning not paid. Our own view is if you allow them to be paid, they will be spending even more time on their athletics and even less time on academics. I don't even know what to say on that. I'm going to be honest. I'm going to be straight with you. If there's one hill that I will forever die on, it's paying college players, men and women. You bring in money, pay them. And there's all these arguments out there, and I'm going to address this in a minute too, that there's so many reasons why you can't do it. There's not enough money. Title IX won't let you do it. Other sports will suffer. And I'm going to address all three of those. I'm going to put together a series. I've been working on it, just figuring out how to address it initially. And I plan on having it out by July. Hopefully I will before they have this ruling done, but we'll see. And so, but there was two quotes by Supreme Court justices that jumped out to me the most, that I feel like are most important for this argument, as well as kind of, defends my argument. First off, Justice Brett Kavanaugh, this is what he stated. He basically went so far as to say that Waxman's arguments circular and disturbing. And this is what he said. The antitrust laws should not be a cover for exploitation of the student athletes, Kavanaugh said. It does seem that schools are conspiring with competitors to pay no salaries to the workers who are making the schools billions of dollars on the theory that consumers want the schools to pay their workers nothing. And then Supreme Court Justice Clarence Thomas pointed out something. He basically pointed out that the athletes who are helping these schools make billions of dollars and are paid nothing at the same time, coaches' salaries are going up. And that's supposedly in the amateur ranks as well. So this is the exact quote from Supreme Court Justice Clarence Thomas. He states, "It strikes me as odd that the coaches' salaries have ballooned and they are in the amateur ranks, as are the players." So with everything I just stated before, there's so much to unpackage in there, and there's so much to research that, and I'm not going to dive into every single justice's statement because I want to give my opinion on all of this. Of course, the NCAA is full of crap, and their goal is to not share the wealth. They want the money, they want their cake, they want to eat it as well. And that's the bothersome piece about everything within their argument, is that he literally said that for more than 100 years, the distinct character of college sports is that it's played by students who are amateurs, meaning not paid. Is that really what it means to be an amateur? Is it? So the definition here in the Free Dictionary is a person who engages in an activity, especially a sport, as a pastime rather than professionally or for gain. So a person who engages in a study, sport, or other activities for pleasure rather than financial benefit or professional reasons. That's kind of ridiculous, because if they're not doing it for any type of game, if it's more just pastime, then why do they give out scholarships? Oh, because they have to entice and give kids a reason to actually go play, right? Especially good ones. Ones that know their talent. That's what it sounds like, is they're trying to find an argument in here to where, well, no, we don't pay them because this is just, them killing time. When in all actuality, it's actually taking all of their time. All of their time. There's so many articles and reports on kids being pressured into going into weaker majors so they can focus on football. They have practice times that are ridiculous, to the point of they spend more time together at the stadium in the practice area than they do probably in their own rooms. LSU just built a whole new facility where they got reclining chairs and TVs and stuff in the locker room so they can spend more time in the locker room. Now, if you say that because they're trying to find a way to keep the kids out of trouble, I can totally understand and buy that argument, but that argument still it's not valid for me. Because it still makes no sense that it's okay for schools to take all the money that they're earning and put it on projects, spend it on campus improvements, facility improvements, and all of this stuff where players are getting a gain, but still say, oh, they're amateurs. They're not doing this for a professional gain. Even though all the coaches that are in this job are doing this 100% for a financial gain. Let's just keep it a buck. You don't want to play the players because you're greedy. And if the NCAA just said that up front, I think people would probably halfway respect them for it. But they won't. They're going to keep lying about it. And the Supreme Court, now, everything I just stated, don't think that this is going to change anything for the name, image, and likeness piece and even player compensation. They're stating some opinions, but that doesn't mean they're going to change anything. Right now, for them, this is them just evaluating the oral arguments, even though the oral arguments are very weak. Chief Justice Roberts don't want the courts to really mold this. And the NCAA is hoping that the Supreme Court says, NCAA, you need to figure this out, to the point of they don't have to figure it out. They can just pretend like it never happened. So they're still in a dogfight. This is going to be long and it's going to be drawn out. Well, at least it's going to be long and drawn out to the summer, because that's when a lot of the laws, like in California, where they're telling them that players will be allowed to profit off their name and likeness, in which other states have also jumped on board. This is the time now, NCAA. You got to figure out how to do the right thing, which the right thing is finding a compensation model for these players. And I promise you, when I put together this piece, it will not hurt the sport if players are getting paid. I mean, hell, if you think about it, most of you fans already think players are getting paid to go to certain schools. And if that's the case, why don't we just make it legal? Speed up the process. And I promise you, all the best players won't go to the same school, because all the best players are going to want to get their own money too. Going to the same team with a whole bunch of other great players is an old man's game. And what the young want that check. And if one school's offering more than another, I promise you they'll go there.